all prepped up and getting ready for that big day when you're no longer that single you, and the night is the night when two become one. To be with you forever, or so you hope that. 2 days before your wedding, you got stood. At least, it's not like that famous movie, The Runaway Bride, or, in this case, The Runaway Groom. All preparations has been made. Can you file or sue the other party for failure of promise to marry? Is there such a thing? Disclaimer. Our videos on laws are based on actual cases. The facts stated have been made public via publications and in the internet. Therefore, should any details, especially of the petitioner and or the defendant, offensive in any way whatsoever, kindly leave a comment or message us in Facebook and we'll be more happy to oblige. Here's what happened to the case of Beatriz Wassmer versus Francisco Velez. It started with dreams and hopes, followed by appropriate planning and serious endeavors, but turned into frustrations and what's worse, complete public humiliation. Francisco Velez and Beatriz Wassmer, following their mutual promise to marry, decided to get married and set September 4, 1954 as the big day. On September 2, 1954, Velez left this note for his bride-to-be. End quote. Dear Beatrice, we'll have to postpone our wedding. My mother opposed it. I'm leaving on the convoy today. Please do not ask too many people about the reason why. That would only create a scandal. Paking. But the next day, September 3, he sent her the following telegram. Nothing changed. Rest assured, returning very soon. Apologize. Mama, Papa, love. Paking. Thereafter, Velez did not appear, nor he was heard of from again. Sued by Beatrice for damage, Velez filed no answer and was declared in default. The court ordered the parties and their attorneys to appear before it to explore the possibilities of amicable settlement. This possibility was given twice. However, the defendant's counsel informed the court that the chances of settling this case amicably were nil or close to impossible. Instead, Velez claims that he has a good and valid defense against his failure to marry the plaintiff, a schedule having been due to fortuitous event and or circumstances beyond his control, and that there is no provision of the Civil Code authorizing an action for breach of promise to marry. The main issue: can a woman sue a man who backed out of the wedding days before the celebration? The court says the mere breach of promise to marry is not an actionable wrong. We pointed out that the Congress deliberately eliminated from the draft of the new Civil Code the provisions that would have it so. However, that the extent to which acts not contrary to law may be done so without consequences. Article 21 of the Civil Code provides that any person who willfully causes loss or injury to another in a manner that is contrary to morals, good customs, or public policy shall compensate the latter for the damage. The record reveals that on August 23, 1954, both parties applied for a license to contract marriage, which subsequently issued. Their wedding was set for September 4, 1954. Invitations were printed and distributed to the relatives, friends, and acquaintances. The brides-to-be trousseau, party dresses, and other apparels for the important occasion were purchased. Dresses for the maid of honor and the flower girl were prepared. A matrimonial bed with accessories was bought, bridal showers were given and gifts received. And then, but 2 days before the wedding, defendant, who was 28 years old, simply left a note for the plaintiff stating, "We'll have to postpone my wedding, my mother opposed it." He enplaned to his home city in Mindanao, and the next day, the day before the wedding, he wired the plaintiff, "Nothing changed, rest assured, returning soon," but he never returned and was never heard of from again. Surely, this is not a case of mere breach of promise to marry. As stated, mere breach of promise to marry is not an actionable wrong. But to formally set a wedding and go through all the above described preparations and publicly only to walk out it when the matrimony is about to solemnize, it's quite the different. This sure contrary to good customs from which the defendant must be held answerable in damage in accordance to Article 21. For express provision of Article 2219, Paragraph 10 of the new Civil Code, moral damages are recoverable in the cases mentioned in Article 21 of the said code. As to exemplary damages, defendants contends that the same could not be adjudged against him because under Article 2232 of the new Civil Code, the condition precedent is that the defendant acted in wanton, fraudulent, reckless, oppressive, or malevolent manner. The argument is devoid of merit, as under the above narrated circumstances of the case, Defendant clearly acted in wanton, reckless, and oppressive manner when he became a runaway groom without even providing a valid reason. And finally, the court ruled that Velez should compensate for the cost of the damage done.